Probation, more commonly known as community supervision corrections, is relatively new. Do we want to say that? It was first established in 1841 by John Augustus, a Boston cobbler who went to the Boston court and asked for custody of a convicted drunkard to help him rehabilitate his life, to train him, to teach him how to become a cobbler, and to give him a career path. This has morphed into what we know today as community corrections. And that is what we're going to be discussing today. So first we want to do is ask, what is probation? Where does probation stand? Are they corrections? Are they law enforcement? Are they social work? Do they work for the courts? Do they work for the Department of Corrections? Are they a county entity? Well, that's a bunch of questions for the probation department, and they straddle them all. Okay, and we're going to get into the balancing act that probation officers have. But most probation departments are considered corrections, but they work for and report to the courts because probation is a sentence that is in lieu of prison. Instead of sending an offender to prison, they place them on probation with the hopes of rehabilitating them and giving them job skills and helping them become productive members of society. But they also have to enforce the law. And they file for warrants and they file for motions to revoke. And there's a lot of things that probation officers do that is not corrections. It's not courts, and it's not law enforcement. It stands by itself. Probation is a perfect mix of protecting the community and rehabilitating the offender. As a probation officer for the state of Texas, or for any state for that matter, you have an obligation to protect the community from the offenders that are on your caseload. And depending on the risk that is posed by the offender, will determine about the level of supervision that is required to ensure that that offender is not going to be a threat to the community. You increase supervision by placing them on a specialized caseload called ISP, or an intensive supervision program. You can place him on a sex offender program. He can be placed in drug court. He can be placed in a domestic violence caseload or a mental health caseload. These particular caseloads are specialized by the officer who works to ensure that he is protecting the community. And if the offender violates the conditions of his probation and he fails to complete with the rehabilitation program, it is the obligation of the probation officer to file a motion to revoke, to have this offender removed from the community. With that in mind, it's also the responsibility of the probation officer to help rehabilitate the offender. Granted, the probation officer can do everything in his power and everything possible to help this offender become rehabilitated and become a productive member of society. However, if the offender is not interested in changing his life, then you have to protect the community and remove him from the community. Part of rehabilitation is you get to know your offender. You conduct assessments, risk assessments, threat assessments, helping assessments, supervision assessments. What kind of programs does this particular offender need to become a productive member of society? And then, wearing your social worker hat, you help that offender. Well, you direct, that's a better word. You direct that defendant into the programs needed for him to become a productive member of society. Once he becomes a productive member of society, you can report that to the court. The court will set him free, and he will be on his way to do what he desires, as long as it's legal. I don't know if you've noticed, but there is a common theme amongst all of these lessons, and that's a focus on the Fourth and Fifth Amendment. We're returning to the Fourth Amendment because offenders, defendants, even once they're on probation, they still have rights. However, uh, the Fourth Amendment states that an individual is to be secure in his home, his paper, and his things against unreasonable searches and seizures. The courts have dictated and have ruled in several cases, I'm going to make you go look them up, that defendants on probation have a lessened protection of the Fourth Amendment because it is part of the responsibility of the probation officer to protect the community from a known criminal. Their protections are lessened. Uh, Probation officers are permitted by the Supreme Court, not necessarily by the administrations and by the chief probation officers and the policies of each individual department. But the Supreme Court allows probation officers to search homes without a warrant because you, there may be an issue that's come about. If you have a domestic violence offender and you have heard that he has firearms, you're allowed to search his house for firearms without a warrant because he is already part of his conditions is submitted to searches. He knows that a search could happen at any time. I know I had a habitual drunk, 7 DWIs on my caseload. You know, they had the intoxilizer attached to their house. But I would routinely go check the refrigerator for beer. I would check the trash cans for empty beer because I knew that this offender was an alcoholic and a drunk. And he complained to my boss, who went to the director that I was conducting searches without a warrant. We had to sit down with the judge and we discussed the court cases. And the judge said that that was an authorized behavior. So, before you go violating the Fourth Amendment and conducting searches on your clients on your probation list, make sure that you check the policies of your department first.